Welcome to the Deep Dive. Today we're jumping into a really common area of confusion, H-1B visas.
That's right. Specifically what happens when you switch jobs or maybe you're planning a longer trip back home.
Exactly. These situations generate so many questions and, honestly, a lot of anxiety for people. Our goal today is simple.
We want to give you a clear roadmap.
Yes. Using what we know, what official channels say to cut through that confusion. We'll look at the visa stamp itself, what you need for re-entry, and those tricky extended stays abroad.
Especially with some of the changes and, well, rumors floating around lately.
Okay, let's unpack this because, yeah, there's so much swirling around H-1B transfers and international travel. It can feel like a minefield. We hear this constantly. Do I need a brand new visa stamp just because I changed employers? That's probably the #1 question.
It really is. Or what papers do I actually need when I'm at the airport coming back?
Right. And what's interesting, you mentioned this before we started, is how easily common assumptions can lead to real problems.
Indeed. Assumptions about what that name on the visa means or how long you can be away. It's not just what the rule is, but why it matters. Understanding the specifics is key.
Okay, so let's start right at the beginning. What exactly is this H-1B visa stamp we're talking about?
So it's that physical sticker, sometimes it's a foil stuck right in your passport.
The one that says H-1B?
Correct. It classifies you as an H-1B worker for skilled jobs in the U.S. But here's the sticky point. The annotation.
Oh, yes, the annotation. That usually has the employer's name, right? The case number.
Exactly. It might say employer X, case Y, maybe clearance received. And because that employer's name is printed right there,
people naturally assume, okay, this visa is only good while I work for this company. It just looks like it's tied together.
Perfectly understandable assumption, but that's the core misunderstanding we need to clear up right now.
Okay.
That employer name. It's just indicating who sponsored you at the time you got that stamp. Think of it like a historical note.
A snapshot in time.
Precisely. It does not control how long the visa stamp itself is valid. Its main job is guidance for the CBP officers, the border protection folks.
So what does control the validity?
Simple. The expiration date printed clearly on the visa stamp. Look for expiration date. That's your key date.
And if it says M for entries?
That means multiple entries are allowed up until that expiration date. So the stamp's life isn't tied to that specific employer listed in the annotation. It's about you, the holder, and that expiration date.
Okay, that's a huge clarification. Which brings us straight back to that big question. You've transferred your H-1B, you have a new job, new approval.
Yeah.
Do you absolutely have to go get a new visa stamp before you travel?
The anxiety around traveling with the old company's name on the passport is real. We hear it all the time.
Well, what's the answer?
For most cases, the answer is no. You generally do not need a new H-1B visa stamp after a transfer if your old stamp is still valid, meaning it hasn't expired.
Wow. So you can use the existing one, even with the old employer's details.
Yes, you absolutely can. Use that valid H-1B stamp, even if it lists employer A's name and case number. The crucial thing, though...
There's always a but.
Well, not exactly, but more like a what you need instead. You must carry all the supporting documents for your new job. That's where the focus shifts.
Right. So the stamp gets you to the counter, but the paperwork proves your current situation.
You got it.
Okay, that's a massive relief, I'm sure, for many listeners. So let's talk about that paperwork. If you're traveling back with your valid old stamp but a new employer, what exactly needs to be in that folder you carry?
Good question. For a smooth re-entry, and critically, to make sure your I-94 record reflects the new employer, you need a solid set of documents. Think of this as your re-entry toolkit.
Toolkit, I like that. What's in it?
Top of the list, the original H-1B transfer approval notice. That's the I-797 form from your new employer. Absolutely essential.
The official approval. Got it.
Then, your job offer letter or contract from the new company. Also, the labor condition application, the LCA, that goes with the new position.
Okay, offer, LCA, what else?
Pay stubs. Especially if you'd already started working for the new company in the U.S. before you traveled, recent ones are best.
Proof you're actually employed and getting paid. Makes sense.
Right. And it's smart to have copies of your old H-1B approval notice and maybe old pay stubs too, just as backup. Plus, contact info for your new employer.
Just in case the officer needs to call.
Unlikely, but always good to have. And finally, just general professional proofs, degree certificates, licenses, things like that.
That's a pretty thorough list.
Yeah.
And, we hear anecdotes all the time. Some people say, oh, they just glanced at my visa. Others say they asked for my I-797.
Exactly. It varies.
So the clear advice is carry everything. Prepare for the most detailed check, even if it doesn't happen. It avoids potential headaches, delays, or worse, issues with your I-94.
Yeah.
Better safe than sorry, right?
Absolutely. It's about controlling what you can control, and having the right documents is squarely within your control.
Now, what about families? Does the same logic apply to H-4 dependents, spouses, and kids?
Yes. Thankfully, it's consistent. If an H-4 dependent's visa stamp is still valid on their passport, they can use it to re-enter.
Even if the main H-1B holder changed jobs?
Correct. They just need to carry a copy of the primary H-1B holder's new I-797 approval notice from the transfer. No need for them to get a new stamp just because the principal applicant changed employers.
That simplifies things for families quite a bit. Okay, let's shift gears to something that causes, well, even more anxiety sometimes. Visa revocation. And that whole 60-day rule confusion. Can your visa actually get revoked? And what about long stays outside the U.S.?
Right, this area needs careful explanation because terms get mixed up. First, yes, a visa stamp can be formally revoked by a U.S. consulate. This is usually called prudential revocation.
Prudential revocation. Okay, when does that happen?
It's typically triggered by requests from U.S. government agencies due to serious issues. Law enforcement problems like a DUI, maybe national security flags. It's not common, but it happens.
And if it does?
You'd likely be notified. And critically, that visa stamp is void. You cannot use it to travel, even if the expiration date hasn't passed. You'd need to apply for a completely new visa.
Okay, that's serious. But what about the old employer? Can they cancel the stamp in my passport after I leave?
Ah, great question. No. Your old employer cannot cancel the visa stamp itself. What they can do, and usually do, is withdraw the H-1B petition they filed for you with USCIS.
USCIS being the agency that approves the petitions.
Correct. So they tell USCIS, this person no longer works for us. That's standard. It impacts the petition status in the USCIS system, maybe showing as withdrawn or revoked there, but it does not automatically invalidate the physical visa stamp in your passport for travel purposes, assuming you have a new valid petition.
That distinction is important. Petition withdrawal versus visa stamp validity.
Very important. Now, let's tackle the 60-day confusion. There are really two different 60-day concepts people talk about, and they often get mashed together.
Okay, let's separate them. What's the first one?
The first is the official USCIS 60-day grace period. This applies after you lose your H-1B job while you are inside the United States.
So if you get laid off while in the U.S.
Exactly. USCIS allows you a grace period of up to 60 consecutive days, or until your existing I-94 expires, whichever is shorter.
And what can you do during that time?
You can legally stay in the U.S. and try to find a new H-1B sponsor, or file to change to another status like a visitor visa or student visa, or file for permanent residency if eligible.
And if you find a new H-1B job within those 60 days.
Big advantage. If the new employer files a non-frivolous H-1B petition for you before that grace period ends, you can actually start working for them as soon as USCIS receives the petition. You don't have to wait for approval. That's huge.
That is a huge benefit. But there's a catch, isn't there?
There is a critical catch. This 60-day grace period ends the moment you leave the United States. If you depart during that time, the grace period protection vanishes for re-entry purposes.
So you can't use it to come back in?
Correct. And if your job ends while you are already outside the U.S., this grace period doesn't apply at all for trying to re-enter. It's purely an in-U.S. benefit after job loss.
Okay, that's the official grace period. What's the other 60-day thing people worry about?
The other one is more of an informal risk threshold related to extended travel outside the U.S. while still technically employed.
Informal, so it's not a written rule.
Correct. There is no official regulation saying an H-1B holder cannot be outside the U.S. for more than 60 days. You could be out for, say, 3 months for a valid reason related to your job or personal matters.
But
CBP officers at the border have broad discretion. If you've been outside the U.S. for an extended period, say 2, 3, 4 months, they might question whether you've actually abandoned your U.S. job.
even if your employer says you haven't.
They might still question it. If they suspect job abandonment, or if you can't adequately prove your employment is ongoing and legitimate, they can revoke your visa right there at the port of entry.
Wow. And this is more likely after longer trips.
It seems the risk increases with the length of absence, especially beyond, say, 60 or 90 days. We've seen reports, particularly from U.S. pre-clearance locations like Abu Dhabi.
Or they check you before you even board the plane to the U.S.
Exactly. There was an incident involving individuals denied re-entry there after being in India for over 2 months. Their visas were canceled on the spot, citing regulations about officers' discretion. even though the individuals apparently had documentation.
So it's a real risk, not just theoretical.
It's a real practical risk. The advice: if you're traveling back after a long stay, be over-prepared. Carry recent pay stubs, your valid I-797, a detailed letter from your employer confirming your continued employment, maybe outlining remote work arrangements if applicable, any lawyer letters affirming your status.
And maybe avoid pre-clearance if possible for that return trip.
Some suggest that as a strategy, yes, if you have the option, to face CBP upon arrival in the U.S. rather than before departure.
So wrapping up this 60-day discussion, understand the intent. Prove your U.S. job is real and ongoing. That's the bottom line, regardless of where you are.
Precisely. It's about demonstrating continued ties and legitimate employment.
Okay, let's tackle a scenario that's sadly become more frequent. You get laid off, maybe you're visiting family outside the U.S. at the time, or you leave shortly after. Your H-1B visa stamp itself is still valid for another year or two. Can you just fly back to the U.S. on that stamp and start job hunting?
It's a very common question now, and the answer is a clear no.
No. Even with a valid stamp?
No, you cannot lawfully travel to the U.S. on an H-1B visa stamp if you do not have a current valid H-1B job waiting for you with an approved or at least properly filed petition.
So trying to enter just to look for work is not allowed?
Correct. Attempting that is considered misuse of the visa and could lead to denial of entry, visa cancellation, even deportation. It's a serious violation.
So what's the right way then if you're laid off outside the U.S. but want to come back on H-1B?
The path forward is, you need to first find a new U.S. employer willing to sponsor you for an H-1B. Then, that new employer needs to file an H-1B petition for you.
And once they file it? Or do you need approval?
Generally, once it's properly filed under portability rules, and assuming your old H-1B status didn't expire long ago, you could potentially travel back using your valid visa stamp along with the receipt notice for the new petition. Though having the approval notice, I-797, is always safer, the key is having that new job sponsorship initiated before you travel.
And the good news is you're likely cap exempt.
Right.
No lottery.
Exactly. Since you were already counted against the H-1B cap, the new employer doesn't have to worry about the annual lottery for you. That makes you a more attractive candidate.
Okay, so secure the job first, get the petition filed, then travel. That's the sequence.
That's the safe and legal sequence. It underscores again, the stamp alone isn't enough. Active, authorized employment is key.
Let's touch on H-1B portability more directly. You mentioned it briefly. How does that work?
Portability is a really helpful provision. It allows someone already in H-1B status to change employers and actually start working for the new employer as soon as that new employer files a non-frivolous H-1B petition, Form I-129, with USCIS.
So you don't have to wait weeks or months for the final approval paper.
Correct. As long as you were lawfully admitted, maintained your status, and the new petition is filed before your current H-1B status expires, you can port your H-1B and begin the new job upon filing. You need the certified LCA as part of that initial filing, of course.
Definitely smooths transitions if you're already in the U.S.
Yeah.
But what if you get the new job offer after you've left the U.S.? Can you still use portability in a sense?
Yes. Building on what we discussed earlier, if you're outside the U.S., you have a valid H-1B stamp from old employer A, and new employer B gets an H-1B petition approved for you, the I-797.
Can you fly back using the old employer A stamp?
Yes. You can use the valid employer A stamp along with the employer B I-797 approval notice to enter the U.S. and start working for employer B.
Even if it's your first time ever coming to the U.S. on H-1B, maybe you got stamped but never traveled for employer A.
Yes, even then. As long as the stamp is valid, you just need all the documents for employer B and ideally copies related to employer A too.
Is there a catch here?
One important one. If your authorized stay with employer A had already expired before employer B even filed a new petition, then portability might not apply in the same way for starting work immediately upon entry. In that case, you'd likely need the employer B petition to be fully approved before you could be admitted in H-1B status. The timing matters.
Okay, nuanced, but the key is generally yes, the old stamp can work with new paperwork if done correctly.
Correct.
Wow, we've covered a lot of ground. From really understanding what that visa stamp annotation means, or rather doesn't mean, to navigating the different 60-day scenarios, and the absolute necessity of having that new job lined up before re-entry if you've been laid off, it's clear staying informed is crucial.
It really is. If there's one core takeaway, it's this. Prioritize having clear, current, and correct documentation. Always. And remember, while the visa stamp in your passport is your ticket to the border, it's your ongoing, provable, authorized employment in the U.S. that truly anchors your H-1B status.
That's the foundation.
Especially when you're traveling or changing jobs, that's the bedrock.
So as you navigate your own H-1B path, keeping in mind that these rules can and do change, our suggestion is pretty straightforward.
Engage with official resources, USCIS website, Department of State. Get information from the source.
And if you're unsure, especially about your specific situation,
Don't guess. Don't rely on forums or what your friend's cousin did. Seek professional legal advice tailored to you. It's an investment in your future.
absolutely. Don't build your plans on assumptions. Build them on clear, verified facts. Your peace of mind is really paramount in all of this.
Well said.
We really hope this deep dive has armed you with some valuable insights and maybe reduce some of that anxiety. All the best out there.
All the best, and we will meet again with another important subject.